Welcome to the Hathaway Kunz podcast. I'm Tyler Garrett, a partner at the firm, and with me today is another partner at the firm, Sean Larson. How you doing, Sean?
Doing well. How are you, Tyler?
Good. We're here today to talk about everybody's favorite topic, litigation. So our firm is at the top of their game on litigation. I think we have some of the most amazing trial attorneys and appellate attorneys in Wyoming, and I kind of want to dig in today as to why that is, why we're successful at litigation, and kind of describe the process upon which you follow in litigation and what I follow, the differences, the similarities, and things like that. So to kick it off, what kind of cases do you have going on right now?
Yeah, Tyler, as you brought up, I mean, we're always trying to stay at the top of our game and learn and experience more. We have a number of business litigation cases going on right now that involve either contract disputes, real property disputes, other issues that are coming up with LLC or corporate governance. And really, I think a common thread between all of those, even though it may not have a family dynamic, it may not seem as emotional as criminal or family law, there's still this immense amount of passion and intensity from the clients because they want the courts to do what's right. And they want to go through the process. They want to have someone in their corner. And when they get to the end of it, they want the court to understand their story and then obviously rule in their favor. And that doesn't happen all the time. Judges are human. But I think one of the key components that is constantly present is this passion of business owners to get this done right, to get into court, to play the long game, and to do the things that help advance their business further, where they offload a lot of the litigation onto us. We're doing a lot of the work and coordinating with them so that they can continue to focus on doing business as well. Because obviously, if you're spending, 40 hours a week as a business owner on litigation and not on your own business, I mean, that's a practical problem. So I think that's a theme of most of my cases right now is there's just a passion and intensity from the clients that they want to see their story heard by the court and then conceptualizing that and trying to put it together in digestible pieces.
Yeah.
So Tyler, what do you have going on right now?
Yeah, I mean, for me, you just had a trial, and we should get into that in Chancery Court. I'm going to trial in federal court for a 2-week trial here in a couple weeks. And, in terms of actually going to trial, I think that's what sets us apart from a lot of firms in Wyoming or in the region or in the country. I mean, we actually go to trial. We try to litigate a case to a resolution as effectively and efficiently as possible for clients. No one wants to spend money on lawyers. We don't. And we don't want our clients to either. But sometimes you got to go the distance because there's uncontrollable factors, the other side, courts, their rulings, things like that. And so, what I've got going on is this federal trial. It's been consuming for the last year plus in terms of motion practice, discovery, and finally, we're headed to trial because the parties simply are not at a position to settle. And a 2-week trial is substantial. We're going to have several thousand exhibits. We're going to have probably 40 witnesses. And that's a large trial to go forward in any court, frankly. But I'm not sure I can remember that size of a trial happening in the District of Wyoming in the last decade or so. So that's what I've got going on. And then in addition, we all have other cases too. As you know, I do a lot of appellate work. So I have an appeal headed to the Wyoming Supreme Court now. I've been consulting on other appeals that have been coming down with decisions lately. So, there's just a lot of mix of different things. And, for us, I think that's just kind of par for the course. But when you take a step back, it's pretty extraordinary as to what we do. We're in the trenches and trials, and for a long time, I thought trials were kind of rare, but it seems that we've been on a kick with a lot of trials with the attorneys in our firm, and that's something that not a lot of firms can say. And although we wish our clients could, would their cases could be resolved sooner than that, our clients trust us to go to trial, put on the case that needs to be put on, and give them a fair shake with respect to the rulings by the court. So, but I am interested to hear more about your trial recently in Chancery Court. As I understand it, we're kind of the first in a lot of ways with the Chancery Court. I think we filed one of the first cases in Chancery Court when that court was originated and created. And then now I think your trial is one of, the first or second trial that go on in that court. But what was it like litigating in the Chancery Court? And I mean, kind of set the scene as to, how intense it is to litigate a case in Chancery Court.
Yeah, really a great experience, start to finish, being in Chancery Court. I think, to step back and kind of give some context on Chancery Court and how aggressive the schedule is and the purpose behind that. So when the Chancery Court was founded, I mean, the goal is to get from our filing, scheduling conference. I mean, there's some additional time that can be built in with service and whatnot, but essentially file the case, and we're going to try to get you to resolution in 150 days. 150 days is a short time frame to be able to get a case from start to finish. And so there are certain dynamics of a case, like your federal case right now. That case is likely far too complicated for Chancery Court unless you get relief outside the 150 days. Mm-hmm. It can be very difficult to try to pull off a Chancery Court case unless you're ahead of the game on the certain issues that you want to address in discovery, on the certain witnesses that you want to call. Are you going to do a little bit more compressed schedule to try to make sure that that trial date fits in within that 150 days? And the goal of the Chancery Court is to get the case done in 150 days. The practicality of that is difficult because you have a period of time when you get the court to a scheduling conference, and that may be a good 30 to 45 days into the case. And then after the scheduling conference, you basically have a window of about 2 months of discovery-ish, and you're going to have your expert disclosures wedged in there as well. And so you have to have your written discovery requests ready to go. You have to have your list of depositions ready to go. You also need to make sure that you have a good plan and approach for your themes so that you can go through discovery quickly. Mm-hmm. If you run into discovery snags, then you're able to get through those things and get motions in front of the court. And if you're going to file a motion for summary judgment or get ready for the pretrial conference or do both, you're going to have to be ahead of the game in discovery to be able to meet those deadlines where there's 20 to 30 days after the pretrial conference, you're going to have your trial. So
like, to put that into perspective just for a second, like 5 months, mm-hmm. right, to try a case in Chancery Court, basically, if it all goes according to the default timeline. I mean, to put that into perspective, in state courts, in the district courts here in Wyoming, I mean, you're talking at least a year and a half, maybe even 2 years out before you get to trial. I mean, that's kind of what we've been experiencing on that state court level, at least in the district court. And then even on the federal court, I mean, we've been litigating, albeit this is a substantial case that's really complex. I mean, we've been litigating for, a year and a half, and that's a long time, for a client and a case to go on. So I just wanted to put that out there. I mean, Chancery Court is an extraordinarily fast forum to try a case, which I think, and I think it bodes well for how we approach cases. We front end load. We're always on the offensive. I think that's what makes us very successful trial attorneys and litigators. We're never just kicking the can down the road. We're always strategizing. We're thinking 2, 3, 4, 5 chess moves ahead. And, in Chancery Court, that really proves its worth because you need to be ready to rock from day one, even before filing. If you're the plaintiff, right? You have to have your ducks in a row because 5 months from then, you're going to be trying a case. And so to me, I think, it's a natural fit in a way with Chancery Court as to how we approach litigating cases. And I think that's why we're successful in that forum as well.
Completely agree. And the context on the difference in length is very important. And that's one of the reasons that you'd consider Chancery Court, along with State District Court, along with Federal District Court, when you're considering your venue here in Wyoming. Really important to think about that and whether you can compress the case down into 5 months or if you need that full time frame. You bring up a great point about being ahead of the game with Chancery Court. You need to be ahead of the game. Your client needs to know their case. You need to know your client's case. And then it comes back to a natural question that comes up in almost all legal work, which is we have a complex problem or maybe a less complex problem. And what are these different inputs? What are these different facts that we're going to have to get into evidence that help us prove our case? And in Chancery Court, we have less time, we have less discovery. Do you want to go on a chase down the rabbit hole in some discovery issue about some witness's personality that has nothing to do with the merits of the case in a Chancery Court case? No, you have to focus in and you have to make it about the issues that are really important. And so there's this additional distilling of your case that has to happen in Chancery Court to where you can take this dispute, say a breach of contract dispute, and go right at the contractual language that matters and go right at the issue that matters. So then when you get in front of Judge Birmingham, the Chancery Court judge, you're able to drill that issue down very succinctly, very simply, so that ultimately after the trial, he can issue his ruling and he can do so with that focus on those issues. Because we've all litigated in cases where a party or counsel is a little bit more scatter pleading, throw everything out there, 7 alternative arguments. That sort of thing really doesn't play well in the Chancery Court, given there's so much focus on, hey, let's get to a resolution, let's get this done. What are the most important issues for the judge to focus on?
Yeah. No, and I think, understanding the dynamic of Chancery Court judge or any judge, I think comes from experience, but also not just, before the bench, but also working for the bench. What I've found really extraordinary about our firm is that if you really take a look at the lawyers that we have in our lineup as litigators, a lot of us, the majority, have all worked for courts. So, I was a federal clerk for the U.S. Court of Appeals for the 10th Circuit for Judge O'Brien back in the day. I was a clerk and a staff attorney for Justice Davis and Justice Foyt on the Wyoming Supreme Court. You clerked for Judge Sharp on the District Court of Wyoming, state level, and then also Judge Johnson on the federal courts of the U.S. District of Wyoming. And I think when you look at all that experience combined with, other partners that have clerked, but also a lot of our associates, they're all coming from clerkships. I think that brings a lot to the table as well. As litigators, we know behind the scenes what's going on. We understand the dynamic of, should this motion really be filed? Is the court really going to appreciate, such a distraction or just being inundated with paper? We're able to make those judgment calls, and they also save costs for the client. Some attorneys try to run up the bill by just filing everything they can and making all sorts of arguments just to say that they've done something in a case. But I think for us, we're more intellectual, more targeted, and more impactful, frankly, at the end of the day. I think we out litigate a lot of other lawyers. And, that was just something that I observed recently was just the lineup that we have of attorneys. So, when you're looking at the courts and you're working with our associates, and based on your experience with working at the court and now, we're kind of getting old. So, we've been before the court a lot now. But just assessing, I mean, your judge is still on the bench,
Mm.
Judge Johnson. In fact, I have a case in front of him now again. And, it's always a joy to be in front of good judges. I think all the judges in Wyoming are pretty darn good. But, Judge Johnson, like, he's a great judge to be in front of. He's very intellectual, he's very considerate, professional. So when you're going before a judge, whether it's Judge Johnson or another judge, I mean, do you have a sense of like, okay, I understand what this judge is really looking for based on your experiences? How do you approach going into the court?
It's a great question. And you understand exactly how this works, having been in your prior clerkships.
Mhm.
I think part of what you're thinking about in a state like Wyoming is just like in any other jurisdiction, lawyers licensed in other jurisdictions, what plays well here, what doesn't play well here.
Mhm.
What is going to gain you credibility with the judge as the case goes on? What is going to lose you credibility with the judge? Does the other side request a 14-day extension and you say, no, we'll give you 1 day? That's not going to play well with the judge. There are all sorts of dynamics that go into that. And you have to think about it from the court team perspective. There's typically a law clerk involved, maybe more than one. There's your judge that's been sitting for however many years. And you have to understand from the experience of others in the firm. And we talk with each other about the judges we're going before. And then also just doing the research on some of the prior cases, having a good idea of what they may or may not like in a particular case. I think that's all important. I think what's completely priceless about a clerkship is the fact that you get to go behind the scenes. You get to be there with the judge as they're processing some of their thoughts. You're assisting them in research. You're assisting them in writing. And you get to see how things go on the other side, so that when you're presenting to the court, you're constantly thinking about, is this something that they're going to like? Is it something they're not going to like? And is it going to damage our case if we take this somewhat ridiculous position on a particular piece of language? And it's just something that's really important to focus on is, who's your audience? I mean, the audience, ultimately a trial could be a jury, but in a lot of cases, for most of the case, it's your judge. In federal court, it could be either your district judge or your magistrate judge on discovery issues.
Mhm.
In state court, you have your state court judge or the chancery court judge. You have to be thinking about your audience and what they're looking for and how you connect the dots on a complicated issue to help them focus in and make the right decision in the case.
Yeah. No, and that's right. I mean, and something, that you mentioned, it does, I think it helps check us too, right? We're not, our reputations are very strong in this state and in the region. And, we don't want to jeopardize those. We won't jeopardize those. That we built them over time for, a long time, many years. And, when we step foot in a courtroom, the judge trusts us that we're going to present the facts that are true and the law that is applicable. Doesn't mean we're going to win every case. The court's going to, rule as it deems fit in an objective and the most informed way. But I do believe that the judges trust that what we're presenting. They may disagree at the end of the day, and that's okay. And I think that's significant. We're not just some faceless person in a suit, and we're just in there passing through. We're there in there daily, and that's something that's significant that we take to heart. That's important to you, to me, to everyone in our firm. And so I do think it provides a necessary check to not make those absurd arguments or to file things needlessly that run up the bill for a client or cost, frankly, precious judicial resources. We're mindful of all those things. And I think we are very professional in how we approach cases. I think we win cases intellectually. We don't let our emotions ever outweigh our intellect. And it's a hard job litigating and basically arguing on the daily with whether it's opposing counsel or whatever the situation is. It is a difficult environment to be in every day in, day out, and keep your cool. But I think we do it well, and I think that's part of what sets us apart. I mean, when you're looking at what we do, I do think there's cases that you could be the best lawyer, and we are, and the result's not going to go your way. You can advise your client that way, accordingly, and they may want to settle, and you can advise that that's a possibility they should consider. And sometimes there are those cases though where it's a toss up, and if you out litigate the other side, you actually are going to um, tilt the scales and win the case. And I've seen that recently in a couple of cases that we've had, and I do think that's a significant victory when we're doing what we do consistently, and it really pays dividends for our clients. So, I think for me at least, when I look at you, you really are diligent and work hard in terms of every little detail in a case. What do you think is the most substantial, I guess, advantage that you bring to the table when a client hires you as a litigator? That's a tough question.
Yeah. And I'm trying to be thoughtful. I'm practicing one of those tips that we talk to our witnesses about answering questions during a deposition or answering questions at trial is take a second, breathe, think about the question, and then thoughtfully provide an answer.
Yeah.
It's something where with me, what you're signing up for is a team effort between the client and myself to evaluate the problem, think about the problem in different ways, talk about some of the options moving forward to fix the problem through different avenues of litigation, through different techniques in litigation, but ultimately working together to put the case together, focus it in for the court, and say, court, here are the 2 or 3 key issues that decide this, and here's why they go our direction. And so I think really what is coming from when I'm helping a client is I'm trying to take on the weight of the litigation and some of the emotions, although we can't take all of that from the client, and say, hey, we're going to keep in touch. We're going to work through the case. You leave some of this up to me. I'm going to inform you on what we're doing, and I'm going to take on the weight and the burden of this so you can continue living your life. And we're going to work together on this to bring this toward the proper resolution. Now, that resolution could be ultimately, hey, other side's here, we're here. What are the pros and cons of coming to a resolution during a mediation? Okay, we're so far apart. This is a case that we hand over the judge, and both sides may not like what the judge has to say, but it's a case that the clients can't resolve after going through mediation and different techniques. And so really, for me, it's a journey with the client and taking on that weight. And then we're in the arena together. We're in the arena together. You signed up. We're going to trial. We're in the arena together. It's a long battle, and everybody's going to have hesitations, mostly in the middle. A lot of times during the middle of the case, during the middle of the trial, during the middle of any difficult task or challenge that you're involved in, there's this weight of, I'm in the middle, I'm not past halfway, the distance is too far, this is going to be too much work, I want to give up. And it's our job at that point in the case to work with the client to continue to take steps forward toward either resolution without the court deciding or not. So what I try to bring to the table with the client is we're going to work on this together. We're going to get in the arena. We're going to get dirty together. And the next steps are all about the pros and cons and assessing, okay, how do we get this closer to the finish line, whether it's by resolution or trial? And I think that's something important because we're sitting in the mud with clients, we're getting in the middle, and we're dealing with things in the arena, and it's tough and it beats you up, and there's emotional moments, and sometimes you and the client have to have some tough discussions, and you're still battling along the entire time. And if you battle together and you both give that kind of effort, then at the end, whatever the result, you still feel like during the journey you've helped them kind of get there. And that's something that I look for in my relationship with my clients.
Yeah,
But
I mean I think that's, and one thing that to really take away from what you just said is you can't have that type of dynamic in relationship with a client if it's just another case in the door and you're just sheerly doing things on volume and you're really just trying to churn. Like, I think that is something that is part of our ethos that we do not do. I think we do not focus on volume and just getting things in the door. We're very selective. We want to make sure that our clients are a good teammate, that we're, and maybe we may not be the right fit for them, and we can recognize that and make it to them to where they need to be with other counsel. So I think we're very thoughtful in how we team up with clients, and when we do, to your point, then we're going into battle. We will take a bullet, right? We will go all the way to the extent we can, provided under the law, to prove their case and help them in any way we can. And I think that's important because, it really is a long process. I think litigation is such a frustrating uh, circumstance when you're a client because there's so many unknowns and uncontrollables. You have a court, you have opposing counsel that may not be reasonable. They may have a client on the other side that isn't reasonable. There's all these things that are outside of your control, and all you can do is focus on providing the best legal representation within your control. That's the, evidence gathering, putting that together, figuring out the law, finding the right law, the cases on point. And that really then propels that case to where it gives your client the best shot. And I agree with you. I mean, it is, no one, I think, would ever want to say, I like litigation. No one wants to be in that circumstance. We're dealing with people in a tough situation, and they got to know that we have their back, and then we're there for them. I really try to make it a point to have constant contact with my clients on my cases. And the only way I can do that is by having not many cases. I want to be able to get on a case and give it my full attention to the, I don't want to just say, oh, I got an hour today for this case. Like, I really want to be able to devote the time necessary to give that case the best shot of success, and have a client on the end of it happy with the result. So I think that's right, and I think that's what a lot of, I know it is with all of our litigators in our firm, that's the goal. Like, we really do care about our clients and the outcome. It's not just another case in the door, and that, I think that's different from other law firm models as well. So, and we have the luxury to do that. We've proven ourselves. We have built practices and a firm that allows us to do that. And it's something that I think is meaningful at the end of the day for us too. I know that when a client, whether it's win or lose, is grateful for what you did for them, I mean, that's something that it makes those tough moments all seem worth it. So yeah, I agree with you. So I think to kind of wrap things up, from your standpoint, what do you see in terms of, litigation going forward with tech and different things, how we can apply more efficiencies to cases to help, clients not face such steep fees and different thing and costs in litigation. But, are there things that you're seeing and sensing in the litigation sphere that, our firm's picking up on, and things that, clients ought to know that we're really embracing technology to help them in their cases?
It's going to seem too obvious to bring up artificial intelligence in response to that. But I mean, sometimes the answer is simple. And artificial intelligence is something that is making the practice easier in some ways, but more difficult in others. It's not end all be all. We can't just we can't work on a case for a client and just plug into AI, hey, draft my argument for me. It's not how it works. That's not how you effectively prompt your artificial intelligence so that you're able to get some assistance. And so it's more complicated than that, and it's understanding where it fits. And so clients coming in for initial meeting, am I going to go use AI to come up with a script for my initial meeting with the client? No. Am I going to sit down and have a discussion with the client about my experiences in this venue, which venue makes sense in the state of Wyoming, work through some of those issues, and then when we get to some of the legal research issues, use artificial intelligence with Westlaw and co-counsel to help conduct research, to help lay out elements, to work with associates to put memos together. Yes, and that can make our work much more efficient. In addition, there are more technologies that assist with depositions, that assist with getting prepared for depositions, taking depositions, that we can use and we can leverage to help build our case better, especially in cases like yours with a huge subset of documents that is nearly impossible for individuals to be going through in a timely fashion. And so the ways you can use artificial intelligence in discovery, the ways that you can use artificial intelligence to prepare for depositions, there are different things that help you be more efficient for the client. But all of that said, you need to be able to keep the client connection. You need to be able to explain to the client how this is put together. And you and your client need to know the case. You're going to go to a deposition. Your client's going to get tough questions about the case. You can't just have them go have AI summarize their case for them and then have them show up to deposition without any prep. So it's something where technology is making things a bit easier, but a bit more complicated. And I think something that we do well at Hathaway Kunz is we're trying to stay ahead of it.
Yeah.
We're trying to stay on top of it. We like to work with clients about it and talk about it so that we have a good understanding of what we're doing and how we get to where we get. And I'd definitely be interested in some other ways that you think that technology is kind of helping us, push even farther and harder in some of these cases where maybe we're able to get another step further or take another step in review of documents and depositions that just help us represent our client even better, given the technology that's out here.
Yeah. I mean, I think we've always embraced technology and leveraged such in litigation to its most effective ends, right? I think with respect to AI, it's an interesting one because you got to kind of trust and but verify. So it helps you in a lot of ways speed along the process of maybe setting out an outline or structuring an argument. But as we all know, it makes up cases. And I think we're not lazy on that front. We always site check and do those things, and we've caught, we've seen different things come to light with other counsel, and we've seen the orders that have come down from the courts here in Wyoming with respect to sanctions for someone not doing the due diligence and checking the cases that AI cites. So I think we're very mindful of how we use it. I do see leveraging technology in a lot of different ways with the AI summaries of depositions. Also, I'm really interested in terms of, demonstrative exhibits and illustrative exhibits under the rules, how we can utilize AI graphics. If they summarize 1,000 different pieces of exhibits, how does that look? And for the efficiencies for a court to consider what that picture is created based upon that objective and competent evidence that you're putting forth. So, I mention it and I raise that issue because I do see us as someone on the forefront of always not really running from change, right? And differences and progression. We don't really sit back and say, well, this is how we've always done it. We really do embrace and enjoy change and really pushing the limits and utilizing everything that's coming down the pipe with respect to progress and technology. So we could talk about it forever, I think, at this point, and how we want to use it and how we think it'll be used and things like that. But I think we continue the conversation again down the road with more litigation topics. But, I don't know. I think we've talked for an awful long time. So I think we wrap it up and then wait for another episode. But I think we consider doing several different tranches or episodes on litigation because there's just so much there. And I think there's a lot of information we can convey to clients and just the greater public about what does litigation mean? What does it look like? And what sets us apart? So if you're willing, we can do this again down the road.
Let's do it for sure.
All
and, we'll get people more informed on discovery processes, depositions, outlooks on certain discovery that they may not have ever heard of before, expert witnesses. I mean, the amount of time we could spend discussing litigation is crazy. So I am glad to, come back and have the discussion again.
Yeah, well, we'll do it. We'll nerd out. So with that, thanks for tuning in to Hathaway and Kunz's podcast. And until next time, thank you.